Morning, everybody. I'm Savannah Guthrie in New York, and we have a decision just breaking from the Supreme Court on a challenge to Obamacare, the Affordable Care Act. And I want to get right to NBC's Pete Williams, who is outside the court this morning. This was the challenge that was brought originally by states opposed to Obamacare. The Supreme Court took on the case. Oral arguments were right after the election. People will remember that. What's the decision?
For the third time, the U.S. Supreme Court has spared Obamacare from challenges, this time from a group of red states who said the individual mandate was unconstitutional and could not be upheld as a legitimate use of Congress's taxing authority because Congress had later set that tax penalty if you didn't buy insurance at zero. But today, in a 7-2 decision, the Supreme Court simply says that the states who challenged it didn't have the legal standing to bring this case. In other words, they've thrown the case out without ruling on the underlying issue. They basically say that the red states didn't demonstrate that they were injured enough by the Obamacare surviving to be able to bring this challenge into court. Now, the Supreme Court in recent years has been very picky about groups that can come into court, what's known for the lawyers as legal standing. And that's the basis of this decision. So this is not a decision on the merits. This is simply a decision saying these states didn't have the legal standing to bring this case. So what this does is it means that in the future, other states could try again the same legal challenge. And if they can find enough ways to get people together and cobble up another case, Obamacare could face yet another challenge. But for now, Obamacare survives again, a 7-2 decision from the Supreme Court rejecting this challenge without ruling on the underlying case.
Yeah, that's what's so interesting here, Pete. They absolutely sidestepped the issue that a lot of the oral argument focused on was whether the individual mandate that required people to buy insurance, whether that was unconstitutional. We recall that it was saved back in 2012 because it was framed as a tax. They didn't reach any of those issues. And I'm looking at the breakdown here of the justices 7-2. So this isn't one of those split down ideological lines. Justice Breyer delivered the opinion, yes. Right, and and I was about to say Alito and Gorsuch were the dissenters,
And they said the court should have taken the case and they would have held the law unconstitutional, but they did not carry the day. They were only able to get 2 of the 6 conservatives to agree with them.
So it's interesting, Pete, because the challengers to Obamacare actually won in the courts below. They won in the trial court, and then that decision throwing out Obamacare was then affirmed at the Circuit Court of Appeals. That decision was stayed while the Supreme Court took on this case. So the practical effect may not be felt, but it's interesting because they won in the lower courts, and now the Supreme Court has said, no way, you had no business being in court in the first place.
Right. So as a legal matter, those lower court decisions, as you know, are now wiped off the books. They have no legal effect whatsoever. But of course, that's been the story with the last 2 challenges to Obamacare. It was the government each time defending it and against the challengers. Now, in the last couple of cases, the Supreme Court did say that the challengers could bring their cases. So this is the first time the Supreme Court on an Obamacare decision has refused to get into the merits. And as I say, it does leave the door open. I mean, frankly, this was the second best hope of defenders of Obamacare. Their first hope was that the court would either say, look, even if the individual mandate is unconstitutional, you can saw that out and leave the rest of the law intact with the coverage for young people and pre-existing conditions and so forth. So their second best hope was a decision like this because it still leaves the door open. It doesn't answer the fundamental question, is it constitutional or not?